Thank you so very much, madam. A very good morning to all. Honorable Chancellor, sir, respected Apur Kumar Sharma ji, and other learned members of the Bar Council of India, and faculty members, ladies, gentlemen, and most importantly, my dear students. Before start of any match or competition, when the teams are all set and yearning to go, the coaches of both sides or all the sides are imparting last minute instructions. At that time, the real players are only warming up and they hardly pay any attention to what the coaches have to say. And their refrain is that, sir, we had enough of your coaching, now allow us to play. And I know it at this juncture when all 64 teams or whoever is present here are yearning to go. It's our interjection to impart you any kind of last minute instructions as to how to go about the mooting or the moot court competitions is not the idea. And I won't bother you much with that. Except a few of my impressions or maybe some sharing with you some parts of the experiences and a little bit of rejoinder to what has been said here by the learned speakers before me. A real life scenario in the first place. You all are, particularly my dear students, and it's for the learned members of the Bar Council of India also, because they are the practicing lawyers, and for the professors also, as to what can happen when we do not pay attention to some of the basics. All of you must have come across certain information, news items, and discussions about the horrors of the use of the artificial intelligence in the working of the of a lawyer, particularly an advocate, particularly in presentation of the matters before the court. It all started with the United States of America, where in one of the district courts, an advocate in support of his case cited as many as six precedents, diseases, judgments, and handed over the hard copies or the printed copies of those citations, which we say. The learned judge, when attempting to draft the judgment, was looking at those judgments, tried to cross check. And one after another, he found that none of them, the six decisions were cited, and none of them existed at all. It was repeated in another court in the United States of America. And these kind of attacks spread like a pandemic. They came down to India also. You must have been aware of an embarrassment of a judge of the Delhi High Court when similarly the cases were cited and the judge was at a loss to find that none of them existed at all. It didn't stop there. Well, it rose to the Supreme Court also. And one of the very senior lawyers in Supreme Court had to confess after having presented with reference to the so-called assistance given as many as 20 or 25 judgments to the bench, and after finding that none of them existed at all, the honorable court was embarrassed, and the learned senior advocate had to say that, sir, in whole of my life, I was never embarrassed more than this. Artificial intelligence, friends, is there for our assistance, our support. The point required for all of us is here, in all these instances, whatever happened. Obviously, some over enthusiastic associate of the advocate presenting the matter must have taken help and support from some tool, some mechanism, got those citations, so called citations, and presented it before, and it was too late before it was realized by all that the artificial intelligence can play havoc. It can even create something which never existed. Stop here, and before it becomes too heavy, appreciate what I had seen during my younger days in the courtroom when these, what to say of artificial intelligence, even the computers were not available. And the mobile phones were also not available. I'm talking of those days when we started our practice somewhere in the year 1981, 82. So this was something that happened in or around the year 1983 or 4 in a division bench of the High Court of Rajasthan, of course. I was practicing there at Jodhpur. It happened like this. There was an intra-court appeal, as we all know. When there are certain matters in which intra-court appeal is permitted. That is, from a judgment of a single judge of the High Court, the appeal is taken to the division bench. So division bench, two judges, very loosely, very many times, keep on saying it double bench. And we always wish that, well, if it becomes really the double bench. Anyway, so we all know as a students of law that this is the division bench. So the division bench, an intra-court appeal, that is an appeal against the judgment of a single judge, was being argued. We were sitting in the court. One of our friends, a little senior to us, he was arguing. Remember those AI instances which I've just indicated and narrated back to you. Our friend was arguing that intra-court appeal, and the honorable division bench was not getting convinced with the arguments. He tried one, he tried second, he tried third. The bench was not getting convinced. Ultimately, the bench asked the lawyer that, gentlemen, look here, we are not getting convinced with this, your arguments. There doesn't appear to be much of the force in your appeal. Do you have any precedent to cite? If there is any judgment in your support? Our friend said, sir, despite all searches, and mind you again, those were the days when we were not having those search engines with us. So he said, sir, I tried my best, looked at all the digests, all the commentaries, everything, couldn't find any direct Supreme Court or division bench judgment. Because as we know, before the division bench, either it will be a coordinate benches, that is division benches judgment, or a Supreme Court judgment that would be binding when you are arguing in the High Court. So he says, I couldn't find any Supreme Court or a division bench judgment, sir, despite all search. But somehow I've been able to find one single judge's judgment. So, as I know that it is not correct to cite a single judge's judgment before the division bench, but if your lordship permit, uh, the bench, in all fairness, extending all opportunities and chance to the learned lawyer, well, said, okay, please cite, even if it is a single judge's judgment. We will see if it supports your contentions. We'll see how this principle has been dilated, has been considered. So he handed over, those were the days now when we were handing over these books. So he cited that decision, and before it could be taken out from the library, just said that, okay, give us that, your book. So the senior member of the division bench read that judgment, which was cited with reference to the head note. Of course, it was cited because he has looked at the head note and cited it. So the learned judge, well, went a little deeper, as is a habit of the judges, that they would definitely go deeper than what you thought of. So the learned judge, started reading into the judgment which was cited, and after having read 2, 3 paragraphs, we could see that the facial expression of the honorable judge were getting changed, and a kind of an patience was, which is expected of a judge, was going out, and a kind of an agony, and then a great sense of anger was being apparent on the face of the honorable judge. And you know what happened? After having read 3, 4, 5 paragraphs of the judgment, the learned judge slammed the book shut and shouted, "Oh, mister, this is the very same judgment against which you have filed this appeal. This is what you are citing." Now, what was found was that very judgment against which appeal was filed, that judgment had been printed in the book, obviously, as with an head note. So it has become a citation. And the very same judgment which was being appealed against was cited as a precedent by the learned lawyer. Now compare. The problem in these citations of the present days, from nowhere being, well, generated and popping out of the artificial intelligence, and citing the very same judgment which is being appealed against as a citation, as a precedent for the division bench to consider. Well, there is something was lacking in both the places. And what was lacking was authentic intelligence. Well, what is needed always is authentic intelligence, even if you are having artificial intelligence with you. That is what is one of the fundamental lessons we should always learn. We should always look deeply into whatever we are going to present. We should always cross check it. We should always make sure that we are expected to be the responsible officers of the court. It was not that the learned lawyer who cited the judgment was intending to play any mischief with the court. It was, you can brand it as an act of sheer negligence or carelessness. It happened in both these cases, 40 years back also, and these days also. What had been missing was application of authentic intelligence, which is available to all of us. My dear students, these moot court competitions are not here, as was rightly indicated by Apurvaji, that the real life courtroom is not a theater, not a presentation of a drama. What we need to learn, apart from our capacity to sift across and scan through all the facts of the case, and to find the applicable principles of law to the facts of the case, which we or to the side which we are presenting, the preposition on which we are relying upon, and then, well, formulating the logical arguments, as was being rightly indicated by the learned Vice Chancellor, that it's that art of logic that one need to develop, one need to understand. It's not, if I may say so, in rejoinder to what the learned Vice Chancellor sir has indicated, that the requirements of being well versed in the principles of logic came from Trivium or any other foreign jurisdiction. One of the fundamentals of which we all can be, need be, and ought to be proud of is our ancient Indian legal system and wisdom. In Shanti Parv of Mahabharat, after all that war, etc., was over, and Yudhishthir was to take reins of ruling, becoming the king, there had been instructions after instructions given to. He sought instructions, and instructions were given to him by different scholars, including Bhishma also, though he was lying on the deathbed. One of the points made was when Yudhishthira was asking about as to who ought to be the advisors of the king, and that included the persons to be entrusted with delivery of justice, administration of justice. The qualities, a lot many qualities were counted there, and those qualities have been well reflected further in Narasmriti also, in Katyan Smriti also. This is a great lead for we all the students of law. One of the fundamentals which had been expected of a true, faithful, and meaningful advisor of the king, a few of those qualities were Vyavahareshu, Dharmeshu, Nyaya Shastra, Avalambana. He has to be well versed in civil laws. He should be a person dedicated to Dharma, the ultimate law. He should himself be the person following the principles of justice and being dedicated to the principles of justice. In that continuity, what was expected of a meaningful advisor and thereby the pillar of any kingdom and any sovereign was that the person ought to be well versed in the principles of law of evidence in the name of that he should be pramanagya also. Praman is evidence, should be pramanagya also, and that he ought to be a Tark Shastri also, a person who is well versed in the principles of logic. In fact, logic remains the soul of everything which we do in life, and it's the core of all the courtrooms. These moot court competitions, friends, are here to sharpen your skills, to develop firstly, and then to sharpen your skills in those principles of logic, where ultimately you can persuade the justice delivery mechanism to accept your viewpoint as being more nearer to truth and justice both. As they say that facts are stubborn things, facts are stubborn, facts remain there. But then law is being called upon. The judges, this is a call for the judges also. That law must bend to do justice. But then that bending of law has to be within the framework of facts. And so, well, articulating your facts, presenting your facts in the manner where the law, the leaning of law is in favor of your proposition. That is what is required to be cultivated by you people here in the rehearsal to the courtrooms. Friends, Stephen Covey, while instructing on the seven great habits of successful people, and indicated something very significant for all of us to always remember, imbibe, inculcate, and well, remain aware of and practice that, and motivate ourselves to well make ourselves the meaningful contributors to the society. What he indicated is that for success becoming your habit, not achievement alone. There's a fine distinction indicated. I'll not be taking your time on those finer distinctions between achievement and success, because every achievement cannot be called success. But then for being successful beyond mere achievers, there are three main components, three main circles which must interject, which must work together. The circle one relates to knowledge. When we need to acquire knowledge, and the knowledge consists of two components: what part of the thing and why part of the thing. Now, during the course of our taking instructions, so far as what part of the thing is concerned, as to what is written in law, what is written in a particular precedent, what is available, what is there, well, we are always willing to, we are always looking for, and we have all the inclination to and dedication to imbibe as to what is written in law, what is written in a precedent, what is the information available? And now you have information aplenty at just a scroll of the screens with your fingers always yearning to scroll. So, what is not difficult to find? The other component of knowledge is why part of a thing. I've always been requesting my law students when you look at any proposition, any principle, anything before you, apart from understanding the what of it, rather learning the what of it, try to go a little deeper, ask why of it also. And once you have asked why of it and got the answer of why, you would be able to understand the whole gamut of whole of the features of the theme of the core of the spirit of any particular provision or law or a particular proposition in a particular precedent or a particular decision of the court. See, for example, as we always salute our constitution, which is supreme, we have the values of justice, liberty, and equality stated in our preamble, fraternity following. Fraternity itself, as Dr. Ambedkar indicated, without fraternity, the other values would not be deeper than coat of paint. But anyway, leaving that aside at the moment, justice, liberty, and equality, the very fundamental words of our Constitution are before us. What is written there, what is meant by them, we keep on taking instructions. But then, with that, in my view, what is needed for all of us to also make aware ourselves of as to why justice, liberty, and equality has been posited in our preamble in that order. Why justice comes first, why liberty comes next, and why equality comes late after that. If we understand as to why this particular chronology, it can't be definitely, as we know, for nearly 3 years, the constitution makers applied themselves with all their learnings into framing out the constitution and giving to us that constitution which is now fundamental to all of us, as to why justice comes even before liberty and equality. Once we have understood that why part of, our knowledge would be complete. What our constitution really seeks to achieve, what our constitution is really up to. What and why is one circle, but then, completing the knowledge, one circle that completes your knowledge. But then, having completed the knowledge is not enough. You need to have the other circle of how part of it, how to use that knowledge. So, after what and why comes how, and how is the point where you all are here today in this moot court competition organized by the Bar Council of India with Royal Global University here in this beautiful city of Guwahati. What and why in the knowledge circle, how, that is the skill circle, that where you develop the skills of using what and why for and using that for the particular purpose for which they are supposed to be used. How to use it, that is where you develop your skills. But, dear students, dear friends, for being successful, having these two circles is not enough. You need to have the third circle also equally important, and that is of want to do it I'm the motivation part of it. When you have motivation to do a particular thing for a particular purpose with all the your knowledge and all your skills, well, then it becomes a combination of a successful person fundamentally, and of course, as a successful lawyer for that matter. So develop that spirit of motivation also while you are taking, because I'm very sure all of you who have taken law as your studies, you've taken that by choice. You want to be a meaningful person, a meaningful contributor to the society. And yes, the moment you would be completing your law studies, you would be a law graduate. You need to inform yourself first that you would be expected to be a knowledgeable person of the society, and not only knowledgeable person, a person who is capable of giving solutions to the problems. And to be able to provide solutions to the problems, you need to have, apart from these two circles of what, why, and how, the circle of want to also, the motivation also. These moot court competitions will definitely help you. And you are yearning to win here. Here you are yearning to win for your team. In the other days, in the real life days, you would be yearning to win for the society. So, friends, with those being our promises, utilize this time, utilize these moments of your moot court competitions to develop into the meaningful members of the society as a skillful lawyer, while understanding very fundamentally that the correct argument, the so-called correct argument or acceptable argument, is often contingent upon the cogency of one's reasonings, cogency of the reasonings, rather than vehemence of your assertions. It's where I will repeat. It's not here that the quantity of citations or any pitch of the volume of your voice or the rapidity even of the speech, the oratory skills will matter. They all are a part of the skill. Well, in the process of persuasion, the art of persuasion, as the lawyer learns. But the fundamental to all that is the cogency of one's reasoning, and those are developed by, well, developing your logical skills, your skills at logic, and at the same time, well, remembering that whatever tools are available to us, including the artificial intelligence, that is available only as an assistant. Don't allow that to become your master. For that matter, I would say that when there is a problem to be solved or a question to be solved, and an AI tool is available to us, there are two ways of using it. I'm never advocating for disbanding or shunning off the use of artificial intelligence. It is there as your assistant. Let it be your servant, let it be your assistant. There are two ways of approaching a particular question or a problem with reference to the availability of the artificial intelligence. One is that you ponder over, you think over the problem, and then you try to find the solution of your own, well, irrespective and without taking help of the artificial intelligence. And after you have, well, framed your solution, after you have framed your answer, well, taking help of or assistance of the artificial intelligence for either fine tuning or for validation also. This is different. This is one way of looking at it. First your own solutions and then the support of artificial intelligence. And the other way, the second way of doing thing would be just reversing the chronology. To my little understanding, it is the first option that would be the correct way of doing, the correct way of taking help and support of the artificial intelligence. That is, of first of all, thinking yourself, first of all, finding your own answers by your own efforts and your methods, and then looking at the artificial intelligence. Mind you, then you would be able to even find faults in artificial intelligence propositions also, or you may not be swayed by what is being presented by the algorithms or by the screen before you. But as we are, our human mind goes, we have the answer already given to us by any tool or any other mechanism except application of our own mind. And thereafter, if we try to apply our mind, if we try to apply, well, our propositions to it, and most of the times you would be failing in altering the answers which have already been given. Because then by that time, your thought process itself would be overtaken by and conditioned by what has been given. So, what is needed these days is to develop skills into proper, appropriate, and meaningful use of the available tools also. I'm very sure in while preparing for these moot court competitions and the four problems, as I was going through those problems, meticulously drafted, um, would be inviting your different skills at different levels on whatever side you are arguing. So compliments to the organizers also for having framed the problems in such a meaningful manner. And there, I'm very sure that all of you must have learned that in solution to these problems on either side of the uh, which of the side, whichever side you are representing, it's not going to be the competition of the number of footnotes or the number of citations. It's going to be the competition of your head notes more. So, wishing you all the very best. Thank you so very much, Yanni.